Greetings, everybody. Welcome to our webinar / podcast / however it is that you want to consume this information. I'm Chris Irons, Director of independent Strata consultancy firm Strata. That's stratasolve.com.au. Alongside me, virtually of course, Frank Higginson, partner, Hines Legal and industry expert of some renown. Frank, welcome.
Welcome, Chris. I thought you were going to start this webinar with greeting Earthlings. Very Mork and Mindy. But no.
No, not today. Now, I am a little bit challenged today. For those watching this, I can usually see Frank alongside me on the screen, but for reasons unknown to me, Frank is frozen to me, even though I can hear him loud and clear. So if you see any weird looks from me, that is why. It's got nothing to do with Frank or me. It's technology. Just a reminder to everybody, so if you're new to the show, we live stream to YouTube and Facebook every Thursday at 2 o'clock Brisbane time. So to follow us, go to Facebook or the Hines Legal page on Facebook and hit the like button and icon, and on YouTube, hit the subscribe button and the notification bell. Absolutely encourage questions, comments, live. Interaction is everything in this scenario. If your inquiry is a little bit more involved, please use the form which will come up in your feed shortly. Fill in your details there and send it on through. Today, very, if I could put it that way, Frank, we're talking about varying management rights agreements. This topic comes up a lot in a lot of different ways, and at its simplest, Frank, it is nowhere near as straightforward as saying we want to change the agreement, is it?
It never is, and I've lost count of the times. Oh, this is a simple one, just do this, and it's just like, don't say that to me because I know it's not going to finish happily. No. So, and I suppose it comes back to the fundamentals of these things. Like management rights agreements are contracts. They're usually long-term contracts. It means obligations on both parties to the contract, and in its simple terms, management rights, is caretaking service contractor, resident manager provides services in exchange for remuneration, but there's a whole lot of detail that goes into that. And so today, I think, is more than anything else. I did a webinar once on my own, which was very lonely when you're away at one period on topping up, which we'll put up as a link. So exercising options, topping up agreements in relation to term. But today I think it's a bit more about the other things that can happen, because like all contracts, particularly long-term ones, they're not necessarily, what you sign today is not necessarily going to be what you need in 8 or 9 years' time. Things change. So, and it's always complicated to make sure you get it right, because if you don't get it right, it might not be lawfully capable of being enforced or given effect, and that can be bad for both sides.
It's a lot of money potentially at stake in that scenario, Frank. Well, let's start at the start then. So what do we mean when we say we're going to vary management right agreement, and what do we actually vary, Frank?
Cool. I think probably the fundamental thing is to remember that a management rights agreement is a contract. And so like any contract, it's binding on both parties. So neither party can change it without the consent of the other. And probably the easiest analogy I use for that with clients all the time is pretend, Chris, I've come to buy your unit off you. And we cut a deal and I say, here's your $1 million. It's a great unit in Nunda, and away we go. Once we sign that contract, that's it. I've got to settle it to buy it for $1 million in 30 days and whatever it might be. I can't turn around to you 2 weeks in and say, oh, Chris, you know what, just make it 900. In the same way, you can't turn around to me and say, oh, Frank, you know what, it's now 1.1 because the market's moved. Doesn't work that way. They're binding. So when we're talking about variation, we need both parties to actually agree. So from a management rights perspective, as the owner of management rights, manager agrees by simply signing a document because they are who they are. They can make decisions in their own right. But from a body corporate perspective, it has to happen at general meeting. That's the only, and that's very prescriptive from a statutory perspective. The legislation is very clear. You cannot vary a management rights agreement other than by approval at general meeting. And that's ordinary resolution.
Why is that, Frank, do we think?
If you go back to what restricted issues are, issues that changes the rights, privileges or obligations of owners, what I think to me the government's trying to capture with this is they are long-term agreements. They are big ticket items. They're not minor spends. So what the government has said to everyone is if you're going to change one of these things, all owners need to have a say. So it's a democratic process in a sense, almost like a change of government, is that owners need to be informed about what's going on, and owners need to have a chance to have a say, and they need to have a chance to vote yes or no. So
Absolutely.
when we talk about what you need to vary, then clearly the webinar we did on topping up is a key one from a management rights owner's perspective to add more term, 5 years, 2 years, 3 years, whatever it might be. But there's a bunch of other things that happen as well. So, we talk about long-term contracts, and we're in the middle of a couple of these at the moment, as always. I mean, in the middle of a couple of plenty of things. But we've got, and this is one we're sort of doing a joint approach for both the body corporate and the manager, as much as the body corporate will get their own lawyer at the end of it. We're starting with the drafting, is the body corporate's made a number of improvements to common property. They've incorporated a gym, they've built in a spa and a sauna, all that sort of stuff. They want the resident manager to be looking after those areas. And of course, the management rights agreement doesn't deal with those because they didn't exist when the agreement was entered into. So we're coming up with a schedule of duties, using an expert to come up with what the remuneration should be for those duties. And then we're going to draft a variation of the management rights agreement to increase the remuneration and increase the duties for that remaining tenure of the agreement. So there's an example of something that might come up. Other things, remuneration can change, duties can change for other reasons. Like one of the things that happens in management rights is you've got an old school, say, style of agreement where, the duties are mow the lawn as required, which in one sense is fine if everyone does it as required, but in another sense isn't that good because it leaves a whole lot of subjective interpretation about what is required. We're moving towards more prescriptive schedules of duty. So it might be mow the lawn once a week during summer and then fortnightly during winter. That's a very simple example. So you might be changing duties and maybe remuneration consequent on that. And then there's other things that happen. And this is, so I showed my age, GST. GST, we've had it now for nearly 22 years, but before the year 2000, we didn't have it at all. So what we had when GST was announced, I think 98-ish, can't remember whatever the election cycle was, is here we go. We're going to introduce this goods and services tax. And so for those of us that have pricing based on events that happen day to day, it was pretty simple. You have an hourly rate plus GST. For contracts that were long-term in nature, and this applied equally to leases, is that the government created a window where contracts would be GST-free for 5 years after the introduction of it, and then GST was going to be applicable no matter what it said. So we had a 5-year window in the management rights industry to run around and get GST or plus GST clauses added to agreements. So that was a left field one, and there's still the odd one that doesn't have that, terrifyingly enough, as much as most of them are flushed out. And then probably the last example is you might, a new court decision. So Gallery V, and we'll put up a link to a newsletter that we did for that, was an example of that where QCAT decided in relation to a particular issue that something that we all thought was the way the legislation worked didn't work. So Gallery V, really, I suppose, innovatively named after the name of the building where the fight was, as they all are, created a whole lot of grief from a financing management rights perspective, and so required lots of variation to management rights agreements. And so we dealt with that from probably 2015-ish or so on. So, you might want to vary your agreement because the duties have changed. You simply want to change. You want to add term. There's some legislative change. There's a judicial change in terms of a particular case. So there's a raft of reasons why you might want to do it. And I suppose that's probably I'd say the big four, if I was going to describe it that way, in terms of why you want to do it.
That's pretty good encapsulation there, Frank. So we talked there about how variation is a matter for all owners at a general meeting, but given the committee is the day-to-day decision-making body for a body corporate, it stands to reason there are some particular implications for committees, aren't there?
Absolutely.
For variation.
Yeah, and it's really, I suppose, mate, as we both know, every committee's different in terms of how they want to interact with their owners and their manager and everyone as a whole. So, like for me, starting with the committee can't approve it. So the committee, to my mind, is a gatekeeper for these things. So the way it works is that body corporate has an AGM once a year. If you put a motion before lawfully lodge a motion before the end of the body corporate's financial year, that's got to go on the agenda for the AGM which is in 3 months of the end of the financial year. So if we have 30 June is the end of financial year, our AGM's got to be by the end of September. You lodge your motion by the end of June, it's got to go on the agenda, rain, hail or shine. So, and from my end, I think probably 2 ways is that one is there's variations that have committee input, and there's variations that don't. And so whether you do that or not depends on your relationship with owners and the committee as a whole and all the rest of it. So from my perspective, I think it's makes a whole lot of sense for managers to engage with their committees if they are going to go and seek a variation of their agreement, because the committee, like it or not, is the representative in one way of the owners as much as the owners are the ultimate decision makers. And if there are concerns from a committee perspective, then the committee can ventilate those ideally before you lodge, but certainly after you lodge and before the agenda goes to owners. And my experience, and Chris, I think probably ask you the same question, if we see something go up as a jointly supported approach, I've never ever seen one defeated.
That's right, Frank. A motion properly presented. Who was it? It was Bob Hawke who sort of came up with the idea of consensus, didn't he?
Yeah.
Consensus leader.
Yep.
Same thing here. Consensus doesn't necessarily mean that everybody is, holding hands and living in the utopia of happiness. No, it's about, okay, I have reached the minimum that I am comfortable with. We are all on the same page on this. We can all see the benefits in being on the same page. So let's be on the same page together. And there's always far more possibility to succeed in that scenario. I think we're agreed on that, Frank. Always far more
we have consensus.
Ability to succeed. Yeah.
Yeah, and it is, and from a committee perspective then, so again, let's go the vanilla variation option. The manager's asking for a top-up. The committee may look at it and say, well, you know what, we're happy to give you that extra 5 years, but we've had some issues in the past with these particular duties. Can we please tweak those to get them to a stage that we're all happy with? So it doesn't necessarily impose a whole bunch of additional obligations on the manager, but it might clarify a few things that are otherwise capable of different interpretations.
Yeah.
And if that then is a negotiated outcome that goes up, and and there's a bit of a win-win in that sense, then it's sort of, there's something in it for both parties. Not that there needs to be, because just because there's something in it for someone doesn't mean there's an automatic downside for someone else. But it just tastes a little bit better when you bring people inside the tent and you do reach consensus. That just makes sense.
Messaging's everything for these kinds of scenarios. Obviously, the message is going to be slightly different depending upon what perspective you come from, but it's still about the right messaging. There's nothing stopping everybody working on that messaging together if need be.
No, 100%.
Yeah.
100%.
Yeah.
You go, mate.
Sorry, Frank, go on.
I was going to say, we'll put up a newsletter, a webinar where we were talking about lobbying your owners and that sort of thing. So that lobbying one was more about, I think, probably coming at it from one side, but there is zero reason why you can't send out a joint press release, for want of a better phrase, to owners to say, this is what we're doing and this is why. And we being the royal we, both sides.
Well, Strata is a selfish thing, Frank, and it should be a selfish thing. This is about protecting your interests regardless of what role you hold in the overall Strata situation. So with that in mind, flipping over to the management rights holder, Frank, what are we talking about there?
Well, obviously, there needs to be some benefit to the owner of the management rights. End of story. So, and that might be a financial one. It might be a non-financial one. The term, in a sense, provides more security of tenure, which obviously helps everyone sleep at night. It might be clarification of duties to reduce the risk of dispute. It might be dealing with Gallery V. And even if that manager is not necessarily financed, it means that when they go to sell, their buyer is going to be able to go to any bank regardless of Gallery V, because some banks have different Gallery V policies than others, subject to how much you're borrowing, all that sort of stuff. So if Gallery V is not an issue, then your pool of potential funders for your eventual buyer is wider. So from a management rights perspective, there's definitely usually. Was it definitely maybe? That was Oasis, wasn't it?
That was Oasis, yes.
Yep, there you go. Sorry. There's almost certainly going to be something in it commercially for the manager, if not dollars, but non-dollars. And then It is very much, mate, that part of that communication about what it's about. Because I think I've lost count of the clients over the years who've taken their support of owners for granted. And it's not actually there. And that doesn't even mean to say that people vote no. It's just that people get their AGM, toss it in the bin, and don't vote at all, which is, apathy reigns supreme in these environments, and that's what happens. I had a client once that lost a top-up motion by 1 vote to 0, and they even owned their own unit and didn't vote. Out of 150 units. That's how apathetic that particular body corporate was. So it's sort of, and they still would have lost at 1-1. They still would have lost, but 2 phone calls and their own vote, and they romp in. So it's those sort of things. So and that's part of that messaging part of it. You know what I mean? It's sort of, you don't need to leave these things sit until the night of the AGM to have the conversation. You should be letting people.
Late by then.
It is, the horse is bolted because there's a bunch of people now, particularly when you can vote electronically. Some, people are always going to. There's always going to be a couple of people there on the night, but I think anecdotally, certainly what I'm hearing from body corporate managers, and Chris, I'm sure you're the same, is that the ability to vote electronically is meaning that more people are participating in the democracy that is Strata. So if you don't actually let people know what you're doing before they've got the ability to cast that vote, you might lose the opportunity. So you've got to be in control of that and got to be in front of that. So don't take it for granted.
It's roughly akin to the current federal election, Frank, leaving all of your big policy announcements for the day of the election. By that point, it's way too late in the process. Same thing applies here. And we come back to what we said about committees. This is about messaging, communication, planning, strategy. If you sort of enter into it blindly and just charge forward, chances are it's probably not going to go according to plan.
And mate, I think the other thing is the messaging doesn't need to be supportive. Everyone is entitled to their own view. Committees can write and say, we don't think you should do this. Managers can write to people and say, we don't think you should do this in relation to committee motions. We live in a democracy where people are entitled to free speech, entitled to have their views heard. And inside the code of conduct that is fairly limited, really, you're entitled to put that opinion forward. So that's part of it too. You're sort of taking for granted that everyone else is going to stay silent is also a little bit of a risk. That might not be the case.
Very much so. That town, talking about messaging, the town hall forum is a really good way of getting that done. That's that step that occurs before the meeting where there's a persuasive element involved, one way or the other. It's just experience has told both you and I, Frank, in very different formats, the effectiveness of that kind of thing.
Information.
Absolutely. And also, well, it sends a message too, Frank, doesn't it? We're making a bit of effort here. We're not taking anything for granted. People really like that stuff.
Absolutely. 100%.
Let's talk a little bit about secret ballots, Frank.
Right. So this is an interesting one. So the way the legislation works in relation to management rights is that it's a requirement automatically that you have a secret ballot for entry into a new management rights agreement or variation of an existing management rights agreement in relation to new term. So you don't need a secret ballot for changes to remuneration, duties, whatever it might be. So what that means is that if it's a secret ballot, secret ballots work where material goes out, you'll have an open ballot paper for the open ballots, minutes of last meeting, if we're doing an AGM, admin, sinking fund, audit, not audit, blah, 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 insurance, et cetera. And at the back end of that will be a separate piece of paper with the secret ballot motion. So that will be yes or no or abstain. You tick your box, you put it inside an envelope, and then you put that inside another envelope, which goes back to a returning officer who's someone completely independent of the body corporate and care of them. So if Chris was the returning officer, envelope would go back to him. Inside that would be an envelope that had your secret ballot in it. Chris then goes along to the meeting on the night. Usually we'll ask the chairperson, do you mind if I start opening these early because it'll take some time? And part of his process then is to go through and say, okay, well, there's Frank, lot 1, he's financial, that can count. So what he'll do is open the outside envelope, put the inside envelope with the ballot paper in it in another box, and churn through all of those papers or all of those envelopes until we've got a box full of secret ballots that are validly cast. Then he'll open all of those secret ballots, and the winner will be what the winner will be. So, and again, we always come back to politics in these things, and I don't know whether I like attributing lots of things to Paul Keating, because as a wordsmith he was brilliant. And I think in politics, the only person you can trust in a secret ballot is the one who says they're not voting for you.
Yeah.
So, and having recently just finished the book on Hawke, Demons and Destiny, so if you're interested in Australian politics, I think it's well worth doing. The ballot where Hawke lost to Keating in 1993 or 91, whatever it was, the traditional approach in secret ballots in politics is to show someone else your ballot paper to prove who you're voting for. Keating and Hawke made a song and dance about showing each other their ballot papers in the ballot for Prime Minister. So clearly they knew which way each one was going. But the context for that, in terms of what we're talking about today, is that you don't know which way people are going to go. So I have absolutely seen both situations where people are saying to committees, I'm going to support you, and clearly, by virtue of the numbers, have voted for the resident manager. And for the resident manager, I'm going to support you, and have clearly voted the way of the committee. So the danger of a secret ballot is that you do not know. And I mean, that's, I suppose, why they were created, to stop people being pressured to change their votes, because otherwise the voting's visible.
Yep.
So in a secret ballot, you can't. And that's why I think, for me, a negotiated outcome in the context of something that requires a secret ballot is usually a much safer bet for everyone, because otherwise you've just got to back what people are saying to you, and they might not be saying things to you that are true.
Yep, that's right, Frank. I think that's a really good point. So true of some of the Strata things. The negotiated outcome is far better than the decided upon outcome, usually. Did you want to talk about the mysterious thing called fraud on power?
I think we should just quickly. It's very rare to see that come up, but that was one that was recently adjudicated on. We'll put the link for that up for people to want to read it. And that's one where a committee made something a secret ballot, because in a secret ballot, it's just purely votes. One vote per paper, away you go. If you're doing special resolutions and things like that, there's two other limbs to get across the line. Leaving aside 2/3 of the votes in favour, must be no more than 25% of the lots against and 25% of the entitlements against, no more than, for that motion to be successful. On a secret ballot, you can't count. On a secret ballot, you can't count the entitlements, which means that it takes away the ability to have a special resolution and also the ability to have a poll, because a poll vote is one decided on entitlements. And so this is one where the Body Corporate Committee knew potentially that they didn't have the numbers, put motion up by secret ballot or made something a secret ballot to take away their prospect of losing on a poll. And that was challenged by the opponents, who were successful, where an adjudicator said that's a fraud on their power to make something a secret ballot to avoid an outcome that they knew was potential. So that's it's very rare, but for contested matters, it's a really important decision, that one.
Well articulated, Frank. Very quickly, want to talk about the impact of the implications on owners and body corporate managers. Our focus has been on committees and management rights holders, and necessarily so. But for owners and body corporate managers, I think for managers, the obvious one there is about making sure there's compliance with the requirements about voting and about the process. Just making sure that all the I's are dotted and the T's are crossed. Easier said than done, because it can get really convoluted very quickly.
But and secret ballots, if they're not sent properly, if the returning officer's envelope's not in there and they go out, then it potentially invalidates the whole process, which can become really ugly.
That's right. And for owners, it's as simple as reading the material, ask your necessary questions, make sure that you vote. My view, I've said this many times when I was commissioner, I'll say it now, if you don't vote, you lose the right to complain later on. That's as simple as that, I think. That's not a legislative issue either. That's just my personal opinion. Very quickly, Frank, pitfalls.
You got to get it right, I suppose. And it's, we looked at one for a client who did their own work copying off something someone else had done not that long ago and they got it wrong. Like even a simple thing like if you're varying a management rights agreement to add new term, you need to include a statutory form called the BCCM 20. Those forms changed when the new regulation modules arrived. They copied something from 4 years ago, which was the old version form, not the new version form. Now, there's not much material differences between them. You'd think on adjudication that would stack up, but it still opens the door to someone contesting that or having an issue with that in due course. So, and of course, it's a very subjective thing to say to get proper advice on these things, but we just see the mistakes. It looks simple, it sounds simple, they never ever are. So, I mean, there's the tick the box to make sure it is squeaky clean from a legal perspective. And the second thing is really, and maybe again, we bang on about this endlessly, and I shouldn't say bang on in a negative sense, it's that communication, it's the narrative, it's you don't want to surprise people and then get ambushed in a sense on the night where people are objecting about whatever it is that's being put forward. And this applies to everyone. It's like, it's just, if you're going to have a conversation around what it is that you're asking for, it is much, much easier to do that in a global sense a hell of a lot time before the night or the day of the general meeting itself.
That's right, Frank.
And we both do that a lot.
Absolutely. It's something I've been doing a fair bit of. I know it's something you're doing a fair bit of. It happens for owners, it happens for committees, it happens for management rights holders. You can't underestimate the importance of that component of the work. Get in touch with us if you think that there might be something there that we can assist with, I think. Which has more or less brought us to the end, Frank. Gosh, that flew by yet again. So I think probably the sum up here is that management rights variations, look, it's a minefield for untested or untried players. Even sophisticated players, it's a bit of a minefield as well. So it is worth your while taking the time to navigate your way through it properly. And our show notes for today's session will reflect that one. What do you think, Frank? Any parting thoughts?
Completely agree, mate. No, that's really about it for me. It again, sounds simple, isn't simple, is never simple. And in the context of long-term agreements, getting something wrong is just not pretty, because it's sort of it can bind people in ways that they don't actually intend. And once it's done, it's done. You can't unscramble the egg. So you get something wrong now and you don't realize it for 3 years. It is very, very difficult to undo, if not impossible.
Yeah, absolutely.
Given limitation periods and all those sort of things. So yeah, do it once, do it right.
Absolutely, Frank. Just a reminder to everybody again that if you are new to the show, we live stream to YouTube and Facebook every Thursday at 2 o'clock Brisbane time. To follow us on Facebook, go to the Hines Legal page, hit the like button and icon. For YouTube, hit the subscribe button and notification bell. That is it for today, Frank. Thank you very much.
Thank you, Chris, as always, and thank you everyone for joining us.
Yeah, no, much appreciated, everybody, as always. We're getting some good feedback. Keep it coming. We're always happy to hear your ideas and criticisms too. We're not that sensitive.
Constructive criticisms.
Yeah, no criticisms about appearance, I think. Well, maybe some. Anyway. Anyway, we will see you next time.
Done. See you, everyone.
Bye-bye.